should be a hat for that.
All right, you need to use your hat, whatever you were going to do with the hat.
I'll just, there's no Chief Poobah. I never even thought about that because I'm so gator-fied. It just wouldn't even occur to me. Now, if it were crimson and gold, the FSU colors.
But that's just like royalty colors, right?
Yeah,
I mean,
it is.
purple and gold thing.
Yes, it's.
Can you raise, make sure we can hear you.
Been too involved in international franchising. Occasionally, I dip my toes into it a little bit if one of our affiliates has a question. But, earlier you said that you thought it was just sort of a haphazard adoption of laws because people thought they had franchising, they needed franchise laws. I'd like to hear a little bit more about that. I just can't get my head around how that works. I've also, thought it was interesting the proliferation of franchise laws around the globe, and thought maybe there was a perception that there were wrongs that needed to be righted, or what's really behind it?
Yes, it's working.
Okay. Obviously, what I said was too glib and facile, and it certainly is not something which can be said about every law everywhere. It is not the case. But I have seen it. I mean, I went to Russia when Russia was considering adopting a franchise law and had discussions with the people doing the drafting. And there was basically no franchising in Russia at the time. But they adopted a franchise law anyway. And there was no reason for it whatsoever other than to say, we're part of the modern world. I went to China, and there was very little franchising in China at the time. But there was the direct selling companies like Avon, et cetera, had gone there and scared the hell out of the Chinese for a couple of reasons. First of all, because they were going door to door, and you didn't do that in China because nobody could hear what you were saying when you went door to door. And second, they were getting large groups of these licensees who were gathering in stadiums together, and they don't like large gatherings. So they said, well, we ought to do something about that. So when the first franchises came over there, they said, well, that must be like direct selling, so we'll just regulate them. And we also think these people are going to take our money and run. So we're going to say you can't do it the way you've done otherwise. You've got to come in here and set up company-owned operations before you do this. I can give you example after example around the world in which, quote, franchise laws were passed, not because there had been any groundswell of concern about abuses, but almost in a vacuum. So when I said, just to show that they could, because America has franchise laws, that's overstating it, obviously. And there are plenty of these that are not that way. I mean, there are some perfectly valid and legitimate and well thought out laws in Australia, for example. I will say it is mostly the Anglophone countries where this has been done this way. But you will not find legislative histories. You will not find ways that you can determine who was doing what and why. And in fact, you will find in many of these countries that the lawyers in those countries barely even know those laws are on the books. So I was overstating it to make a point, but it is, in fact, a disturbing picture. And one of the disturbing parts of it that I called sort of social experimentation is that in many cases, this is not aimed at franchising. It's just collateral damage for some other social movement that's going forward, which takes the form of a particular piece of legislation of which this is part. But it makes it very difficult for multinational franchisors to go around the world because they can't do what they do in America and basically, make a little bit of adaptation for Arkansas versus Oregon, but otherwise we do the same thing everywhere. That's very hard to do internationally. That's what I was saying.
Yeah, and that sort of leads me into one of my next areas I'm curious about is in terms of even knowing if your business is subject to these laws? I mean, are there even developed concepts about, what a marketing plan is or what the definitional elements? Is there any way to, how do you, what do you advise a client when?
Well, my paper goes into this in terms of some of the fuzziness between concepts, and it is more difficult, and there are many fewer people that can give you guidance. And the answer to most questions you ask, even if a law has been on the books for 10 or 15 years in some of these countries, the answer for most people is too soon to tell. We haven't had enough experience to know. Even in the loi du bain, which has a concept that doesn't exist anywhere else, called a market study. Mm-hmm. You're supposed to give a prospective franchisee something called a market study. Well, that's, of course, exactly the reverse of what you are told in the United States, where if you did that, you would be violating the law. But if you talk to a group of people who purport to be franchise lawyers in France and say, what does that mean? There will be one who will tell you, you've got to have a full-fledged study of the particular market that franchisor is going to sell into, how much study he's done in terms of what the potential buying power is, et cetera, et cetera. To the next lawyer who will say, oh, we don't pay attention to that at all. So it is far more difficult, and it's not just it being an earlier stage, it's just a more primitive conditions in many places around the world. Even in loi du bain, which is the first country outside the Americas to pass a franchise law.
But don't you think part of that, Phil, is just, and this isn't just France, but a lot of countries, I think their legal traditions are, because they don't report cases as much,
Yep.
They just don't have as much information. I'm always surprised by how territorial they are often about the cases they've handled and the results they've received. Sometimes they're magnificent results, and yet they're kind of very close to the vest in terms of talking about it, because it's almost sort of proprietary information for them for future cases.
Another way of saying that is we're just spoiled.
Yeah, well, we're spoiled by all our court reporting.
We have this insulated system. We have the system in which we get the benefits of all this. And you're right, most places we don't.
Jurisdictions.
Well, and I had a follow-up on your first question to ask Phil. There is clearly a lot of variation from these countries to countries in terms of the laws that they're enacting. Is it, for those countries, are they also doing that without too much foresight as to why they're doing it? And if so, do you think it would have been better if they just, as long as they were going to pass a franchise law, just model it after some system, the Australian, the American, something, and just adopt it whole cloth and not try to fiddle with it and come up with pilots and things like that from country to country?
I do think that, but of course that's from the point of view of somebody who likes to deal with, who has to deal with it. It makes it easier for us. There are some which say we're modeling it on, and clearly the FTC rule is the single spine from which most of these flow, but a lot of variations and a lot of different vertebrae, I would say. Some have followed the Australian model. But yes, there is much more variation, even so much so that I can show you a PhD thesis just completed studying within the European Union, which you would think if ever there were a place where different countries would have similar approaches, pointing out the number of disparities within the European Union on this.
Yeah.
That tells you how far it's gone. So yes, there is a great deal of disparity.
That's Mark Abel.
Yeah, Mark Abel's paper. Right?
He's turned that into a book on EU franchising, which is interesting to me, because when I talked to him a few years ago, I would have thought that he would have come at it a little differently. He seemed much more, we don't need any of this, and in terms of regulations and laws. And then I think he looked at what had been created in the EU and came more to the conclusion we need some sort of uniformity at this point. We need regulation at this point. It's the cat's out of the bag, however you want to phrase it, and we've got the worst of both worlds. We've got the regulation, but we don't have any efficiencies or uniformity associated with it.
just a comment. In the field of sales law, there was a disparity between states regarding the local sales law. And there was a successful attempt to unify sales law in the world, an attempt by the UNCITRAL, and we have the Vienna Convention. And the question, maybe Phil will have a good answer for this question, is why in the field of franchising there is no successful unification. However, in the field of sales law, there is a very successful unification, the Vienna Convention, the CISG.
Well, I devote a lot of time on that subject in my paper under the heading of uniformity, while we don't have uniformity. And there, the only way we've had made any progress is a paper called Commonly Used Terms, done by the International Bar Association, and it was called Volume 1, and there was never a Volume 2, which tells you a little bit about the lack of progress. But so there is some progress in terms of terminology. But UNIDROIT, which is an organization based in Rome, it was an outgrowth of the League of Nations, and it is designed to do the same thing, which is to take common subjects in private international law and try to produce common law. Well, they spent close to 15 years trying to have a model disclosure law for franchising. I participated in those meetings. And it ended up producing, frankly, a very useful paper for anybody who works in this field. It has some very thoughtful discussions, annotations, et cetera, and some very sensible suggestions, none of which were ever adopted by any country in the world. It's been translated into many languages, totally uselessly. So there are several different languages in which it's gathering dust. And why that is and why it differs from other areas, I don't know. I think a lot of it is personal pride. A lot of it is nationalist pride. A lot of it is some politician who thought he would get some benefit out of this is not going to stand for seeing it rolled back and changed and made like other countries. But whatever it is, in my paper, I conclude that's not going to happen, and we should focus our attention, as you say, the cat's out of the bag, and the question is, what can you do anywhere else? And I think we should focus on countries where there are not laws, so that if in Israel tomorrow a politician comes along and says, we need a franchise law, and he probably will, you could provide a useful service if you could say, let's do this logically, let's do it based upon experience elsewhere, let's don't do this based upon somebody's impulse. And that's what usually it is.
I mean, I do think the CISG is a pretty fundamentally different type of instrument than you would need in the franchising setting, right? It's facilitative. It can be completely contracted around. Parties can just opt out of it. Mm-hmm. And you could never have that with a franchise regulatory statute, because the whole point of protecting franchisees is that you don't want it to be contracted around. So I'm guessing it was a lot easier to get to some agreement on the CISG, because if people decided if they don't like it, they just don't have to agree to it, or they can agree not to use it.
There has been some work done making some progress, not on uniformity of the ultimate contractual documents or relationship, but on understanding. I mean, a paper was just published this week by the International Chamber of Commerce on the use of franchising as a tool for expansion and international expansion. Just produced. And all I've done is look at it briefly, but it looks pretty useful. Whereas almost 10 years ago, the ICC tried to do a model law, and it was an utter and total disaster, because the process was hijacked by a group of European lawyers who were sure that they knew the right thing to do, and what they produced was a document which was aimed at unit franchise sales, which essentially do not exist cross-border, but that's what they didn't know that. For product distribution, so therefore of no real value to most franchisors in the world, and it has never been looked at since the day it was published. So they got smart after 10 years and did something better this time around. That doesn't change the question of uniform laws, but it does say that there's a little bit of centripetal movement toward understanding of franchising.
Mm-hmm.
Do you see any competition among jurisdictions to try to attract franchisors? I mean, you see a little bit, because in the arbitration setting, the whole idea is you want people to do arbitrations in your jurisdiction. So you bend over backwards to adopt statutes that are favorable to arbitration. And what you all have been talking about are not, those sorts of statutes aren't going to attract franchisors because they're designed to protect franchisees. But the ICC statement, as I, from the brief description would understand it, would suggest maybe the opposite, right? That maybe there is room for countries to say, we want franchisors to come set up here. Now, it's not going to work perfectly, right? Because everywhere there's a franchisee, they may well be subject to that jurisdiction's laws. But it would seem to me there'd be some potential for jurisdictions to compete to attract franchisors.
There is, but there's also, the United States stands almost alone in its laissez-faire approach. The United States does nothing whatsoever. I think there's 1/2 of 1% of the Department of Commerce assigned to this. Does almost nothing to help promote and develop franchising. They protest and say they do, but they really don't. They don't do anything to help bring franchises into this country. They're coming in almost despite government policy. And they're coming, believe me, they're starting to now. But many countries around the world try to promote franchising by their own franchisors, as well as welcome franchises to come in. Now, sometimes they get nervous when they think the big multinationals are going to come in and drive their own companies out of existence and so forth. So you get a little bit of protectionism there. But in general, most countries around the world, to the extent they know about it all, are more positive about franchising even than we are. We give speeches, but we don't do anything besides that.
Yeah. Another area where I think you see some movement, and long-term it may bear fruit, are these codes of ethics that a lot of associations have adopted. And there's more and more movement towards uniformity there, I suppose, because since they aren't law, I think maybe associations have felt it easier to kind of adopt very similar, if not the same, principles as other associations.
You're absolutely right on that, by the way. It's very common to see a letter from one franchise association to others saying, would you please send us copies of your codes of ethics because we're going to adopt one and we would like to use. And so there's a lot of commonality there. And now there is something called the World Franchise Council, which posts these, and you can take a look at them. But yes, codes of ethics. But big question is whether or not they have any teeth or not.
Well, and model contracts have been another move, but I think the problem there, you're getting closer to an intersection with the way the law works. I was at a meeting of the International Chamber of Commerce and the International Distribution Institute, and they had a model contract that they had revised, and it clearly was completely unacceptable from the point of view of practicing Anglophone lawyers, because it just didn't fit in with so much of the practice in the Americas or even in Great Britain. But you could see pieces of things like that, especially as lawyers and practitioners actually talk, could be adopted. It really doesn't satisfy any desire for uniformity, but it certainly could create an environment in which you're more likely to have best practices maybe that work across borders.
Let me ask a question to all four of you, since you're all academics. Do you know anything? There's an organization called the Society of Academics, which is people who teach franchising or something close to franchising or who are interested in franchising.
The ISOF.
ISOF, yeah.
Did any of you participate in that at all?
Yeah, I participated just a couple of months ago in New Orleans.
Were you in it? Well, I didn't see it.
Yeah. I've been there.
I've been, most of it is frankly, and I get a copy of their papers afterwards to see if I'm interested in it. Most of it is so esoteric that I don't go further because, I conclude there's no hole too small for some rabbit to go down. Yeah. But I just wonder whether any of you have found any value of that.
I went to one a few years ago, and I don't know how you felt. I felt sort of the same, that the law pieces that were done were great, and there was a lot of commonality with the Australians and others who presented law, marketing, economics, finance issues, if I could understand them, were interesting, but it was hard to see exactly how it would fit in. It would almost certainly not fit in well with practice. It might fit in with academic work. And then on the other extreme, what I've found is I'm going to be going to this meeting in Turin, and I've been to one in Amsterdam, and I've enjoyed the IDI because they're European distribution-oriented lawyers, but their approach is quite different than here in the Americas, and they're all lawyers. So what they write about is all in the same area. It's not like finance and marketing, all that, but their approach, because it's European-based, is a lot different. So unfortunately, there's not a happy median I found. Those are the two organizations I've been involved in, and neither one exactly fits in like, say, the ABA would, except the ABA is still more practice-oriented than academics would like.
Yeah, most of the papers are not legal in these conferences, and they serve franchisors and franchisees more than lawyers. And there are interesting things there. For instance, I read a paper in one of those conferences that states that, how to increase the level of satisfaction of franchisees, how to reduce the number of conflicts with your franchisees, many managerial techniques in order to achieve these goals. So as a lawyer, I didn't find any connection to my research, but I think it may be interesting for franchisees to understand what are the antecedents, what are the reasons for conflict between franchisors and franchisees.
Well, I mean, it's an echo chamber. They're talking to each other mostly. I'm not sure who else besides.
Well, the good thing about those organizations too, and you all have probably felt that in interdisciplinary work. I know Norm gets that in a business school. I get it in a business school. Is when you're one of the few in law and most of the people around you are in business, other business disciplines, part of your mission almost becomes to be sort of the ambassador for what the law is and inform them. Yeah, because you will be amazed, and I'm sure I do this in their field, but you will be amazed at how often people will say things, basic things about contract law or torts or some other concept, and they're just wrong. And yet they're very well regarded, finance professors or whatever.
And they also don't understand that a lot of it's state by state, and there's not a central regulator because they often study public companies that have one regulator.
Yeah. Well, it's usually based on, these are people that don't like lawyers talking about cases because they say it's all war stories. Give me stats. I think they would like Chris because he gets all these stats, but they look at a lot of the common law and say it's just stories. But then I am convinced that a lot of what they say about the law is because they were talking to a friend of theirs who's a lawyer or something like that. Yeah. It's one incident.
Or because they lost a case 20 years ago.
Yeah.
But then, there are several important scholars like Rajiv Dant. There are several important scholars from the marketing area like Rajiv Dant and Patrick Kaufman. They write academic papers, but then I think that they also consult. They give consulting and they participate as directors of franchisors. And there is a communication between their academic literature and the real world.
Well, there's also, are you familiar with the University of New Hampshire program?
Oh, yeah.
It's named after Bill Rosenberg, who founded Dunkin' Donuts. And that's focused really exclusively on international franchising. So if that's a subject you get into and you want to know if there's anything been written on it, that's a place to look. Mm-hmm. University of New Hampshire. Not a place to go, but a place to look. Yeah, but, go ahead.
And what is your opinion about the contribution of legal academia to the real world of franchising? From your perspective, because it's maybe a tough question.
Well, I get nervous when lawyers start trying to talk about something that's outside their area of expertise. I get nervous in my own law firm when partners in my law firm have no compunctions about giving business advice to clients. And I ask them, where did you get your credentials to do that? Well, I'm here. Because I think we have to be careful about not extending ourselves beyond what we're really qualified to do. So on the other hand, I spend most of my time as being the only lawyer with a group of business people. That's where I find what I do. So I'm preaching the gospel to the heathens. But it's interesting, but I get nervous sometimes as whether or not we're being relied upon for something we really don't have the qualifications to be relied upon for.
On that, if I could jump in on that note, and maybe picking up some of the themes that were discussed earlier today, in the interest of disclosure, I gather I might have been the only franchisor in the room today, but the concept of termination and free riding, how it affects the network and all of these things, could you give me your insights and maybe how you counsel clients on, from the franchisor's perspective, when they've got both company managed locations and franchises, but you've got maybe a bad actor in the franchise network that the other franchisees feel are pulling down that side of the house? The franchisor's obligation, and obviously you're trying to rehabilitate, you're offering periods and forbearance, but at what point do you have an obligation to just pull the plug and terminate because of the bad overhang it's having on the franchise side of the business?
That's a very interesting perspective, because when you hear people talk about this subject, it's almost always on the pure vertical relationship between the franchisor and the franchisee. What should be public policy regarding, if there should be any? Should there be laws governing that? Should there be restrictions on freedom of action, et cetera? Without giving attention to the fact that it's also a horizontal relationship. That franchisee is one of a group of similarly situated people, and that you have an obligation to all of those people to maintain the standards of the network. And if you don't do whatever you were thinking of doing vis-a-vis that one franchisee, and this goes back to corporate governance, what's in the best interest of the entity, that you may be doing great damage to the entity and to your obligations to lots and lots of other people. So I think we have to bring that to bear, and I don't think that conduct by a franchisor to take into consideration what the effect will be on the other franchisees should be dismissed, as too frequently it is dismissively approached. I think it's probably the most significant responsibility a franchisor has is to the network, and I think that's got to be the number one criterion that's followed when he decides what he does or doesn't do within the constraints of law vis-a-vis a particular franchise.
I think part of the problem there is, and I may not be up to date on the latest developments, but I recall writing an article 15 years ago on discrimination. Actually, they became two articles. One was sort of more an affirmative action, trying to get more minorities, women into franchising. The other was more on the sort of the straightforward issue of, you know, I treat Chris differently as one of my franchisees than I treat Phil. And I found it very difficult for any kind of legal claim to be made by Chris, say, against me for, you know, my discriminatory treatment. He didn't really seem to have a third-party beneficiary, you know, right, because the idea is each of these contracts, despite the fact that I clearly have a duty to everyone, each one of these contracts was a discrete contract, and the courts didn't have any problem typically in saying, you know, this contract was entered at a certain time, that contract was entered later, they're not necessarily exactly the same terms, they're different territories, et cetera, et cetera. And so it may not be fair to Chris, but it was very difficult for Chris to make any sort of claim that, you know, I was treating Phil better or him worse.
Well, the best example of that is probably covenants against competition. Because every time you decide what, if any, action to take in terms of enforcing or not enforcing, or the degree to which you do enforce, a covenant against competition for Mr. X, the truth is it's Mr. Y and Mr. Z who have the most to gain or to lose by what you do. Now, I have not found cases in which Mr. Y and Mr. Z can successfully sue the franchisor for not enforcing the covenant against Mr. X. But the truth is, they are the real parties at interest. Now, I think there was a Michigan case on this many years ago. Go back and take a look if there's not a case called Exercycler of Michigan. Okay. There's a franchise. I think it's probably 25 or 30 years old. Right. But I know that there's almost no law on it. But that seems to me to be where the rubber meets the road in the issue that's being raised here, which is covenants against competition.
Yeah. I mean, so those things, there's always this, I mean, I have a project now where we're surveying literally 10,000 people with some co-authors about their view of non-competes generally across workers across the country. But one question we want to get at is this chilling effect. So the fact that it's in the contract, does it scare people from leaving? And that selective enforcement is what well is a problem.
Does it scare people what?
From leaving. So if you're, this is a study about employees, not franchisees, but whether or not they decide to become an entrepreneur or to leave or to go to a completely different industry based on their fear of the non-compete. And so one thing we're asking them too is, what do you know about your coworkers and what's your perception of enforcement? So I think as a subset, it would be interesting to see what
Well, I can tell you, as far as whether it has an effect or not, I can tell you that we've had a number of situations in which clients came to us and said, we've got the most terrific prospect in, you name it, Mexico, wherever it is, and it's going to be just fabulous for us. And we suggest that they look into whether or not that company, because it's usually a multi-brand franchisee with other systems, to see whether they've signed a covenant against competition with that other company. And they say, well, that's his problem, not ours, isn't it? We say, well, no, not really, because you can get sued for tortious interference or its equivalent in that country. And we get them to get either an affidavit or better, an indemnification by the franchisee in case they do get sued by the other franchisor because of violation. So the answer is, whether you have signed a covenant against competition is very meaningful in terms of of your view of leaving the system or doing something else.
And to go back to this point of sort of third-party rights or one franchisee's right with respect to the franchisor, to go back to your original question, as I understand it, part of the problem too becomes if the only recourse is to go to the legislature and complain and try to have what I think California had or has in terms of a law that sort of says, you know, you got to have the same terms offered to different people, and you run into some real problems if you have different terms, is you end up with a club to deal with what really might be an issue. Maybe it's not as small as a gnat, but it would be probably much more effectively if it's really just, to go with my example, Chris having a problem because of my treatment of Phil. Instead, you have to pass some sort of legislation that covers everything in all situations, which really isn't necessary.
And there's another factor which argues for uniformity of treatment in that situation. And that is that if you're dealing with a subject matter in which the standard of a court in enforcing it or not enforcing it or finding it to be reasonable or not reasonable is what you've done otherwise, it's very hard to tell a court that the covenant against competition is not unreasonable in scope when it prevents X or Y if it turns out that you've routinely chosen to ignore it in other cases.
Yeah.
So you are basically laying the seeds of your own destruction when you don't do that.
Yeah, you might even have some sort of estoppel type argument.
And in non-competes, you're showing irreparable harm. If you weren't harmed that time, why are you harmed now?
Very hard to argue that. When
Go-
you say,
right.
oh, well, I just forgot about it that time. It's very hard to argue. Mary Beth, fire away at us. This is you're getting CLE credit. You ought to earn it.
I
please.
should be.
Go ahead.
If I could sort of change the subject back to something that was touched on earlier, but which is of great interest to, I think, to me and a lot of people who represent franchisors, and that's the whole vicarious liability and how that's developing. And it just seems like, just looking back over the cases seem like they're all over the map. You can't really draw any hard conclusions. It's kind of hard to advise clients what to do. The areas I see kind of developing are the sort of, well, you've got the premises liability and the security issues, and the cases I think are in California, and there's one somewhere, I don't know if it's Kentucky, Tennessee, involving, I think it was KFC and employees claiming that the franchisor was liable for their employer franchisees' harassment. Now there's this McDonald's case here in the Bay Area where I think McDonald's has been sued along with the local franchisees for wage and hour violations. So that whole area is one that, continues to sort of swirl, and, there's just no clarity that I can see at this from where I sit. And throughout my career, I've sort of waffled between, do you exert the control and just try to minimize the franchisees' screw-ups, if you will, and thereby take on the duty, so if you get sued, you're going to have less ability to defend and say, I wasn't in control, but at least maybe you've reduced the incidence of possible lawsuits? Or do you just throw up your hands and say, we don't do anything, we're not going to exert control in this area, and so if we get sued, we have a better defense? You hardly know where to land on that. Maybe with good insurance and indemnification in your agreements, but
I've heard from at least a couple of people with some experience, business people, who seem to be following more and more a model of, if they've had enough incidents, and it's probably more than one or two franchisees, that they've adopted a model of more intervention and assume they're going to be sued anyway under some sort of claim of either actual or apparent authority, and it's better to just institute programs that leave them more vulnerable to the claim of control, but perhaps less likely to have incidents in the first place, because they're really forestalling sexual harassment
Right.
and wage and hour problems and things like that.
And to me, there seems, in my mind, there's kind of a distinction between the consumer type claims where I can sort
Yeah.
of justify
Oh, yeah,
that
okay.
control because I'm protecting my brand too,
Yeah.
and getting involved in, more of the regulatory side of things with, like the wage and hour, or the employment practices areas that have been the subject of a number of cases. I have a hard time kind of adopting that approach when it's not a trademark related.
And another issue there that comes up, I know it came up at least in a couple of these sexual harassment cases, which seem to be sort of some of the more recent cases, are you have franchisee workers who are no more in the loop than the consumer out there. The first time they find out that they don't really work for McDonald's is when they talk to a lawyer about the harassment or whatever.
They haven't looked at their paycheck.
They figured, it's just whoever signs their check, but it's not really.
Are any of you familiar with a man named David Weil, W-I-L? He's just been confirmed to a position on the NLRB. And his history is one of studying what he calls, a term I had never heard before, fissured industries. Is this something that means something to you, fissured industries? It will by next year, because he is going out and make speeches around the country, and his confirmation was not able to be blocked. His theory is that there are industries in which you should essentially ignore whatever legal structures have been set up between them, but you should look only at the way in which they actually act, so that you should ignore the legal difference between a franchisor and a franchisee. They're not different, and they should be treated as one entity. And that's going to have an enormous effect, to whatever degree that's accepted, in the labor field, in the tax field, in the liability field, et cetera. So, your basic question is the one we've had forever. Basically telling a client, how do you go swimming without getting wet? It's just a very difficult thing to parse. But the stakes have just been raised within the last few months in this field. And you should all, frankly, as academics interested in business, is something I think you probably should be looking at, because this is a very portentous development in my view.
Well, it sounds a little bit like, what is it called? I really should gotten more into an enterprise liability or some of these other issues where it may not be the whole industry, but they look at the standard within a particular company and its associates, whatever you want to call them, its network, and say, well, you're all part of the same process. And it's been used for years and years, in a sense, in environmental law, hasn't it, in terms of, you don't really get to contract away some of your responsibilities with, Superfund sites and things like that.
Yeah, if you own the land, if you've ever owned
Yeah.
the land, but, these are franchisors who've never, they don't own the business, they don't
They
have
don't own the workers.
They don't have the contract with the workers, they aren't
Yeah.
there to make sure that they're getting, it's kind of a frustrating area because, the perception that there's an enterprise, I think, or a single enterprise is greatly overblown in most franchising.
I think
But
it's
also the steps taken to rebut that are also childish. I mean, this whole notion of, when you get run over by the truck, that as you look up over your broken leg and on the back, just above the license plate, it says, we're an independent company licensed by. Oh, well, that's good. I guess I have nobody to sue in that case, right? I mean, we're all sort of fiddling with this stuff around the edges. But I think this is going to bring it into sharper relief, the public policy side of this.
And by analogy, the only other thing, and there are others who may know much more on this than I, but my impression has been in areas like websites and the like, you have some of these same issues of, you have a website, how much involvement do you have with it the moment you start, monitoring and possibly editing, removing posts, then you put yourself in the position where, but if you don't do anything, you've got your brand there on the site, and you can probably post all you want that, this is, we don't make any changes or comments, but people won't accept that. They'll see the brand there, and they'll say, something was posted.
Yeah, the other place where this is going to start to have a real bite is in the data privacy area. The Federal Trade Commission has just ruled against Wyndham, the hotel company, based upon information that Wyndham was not taking sufficiently active steps to make sure that its franchisees were protecting their customers, the people stayed at their hotels, from hacking and getting the information about those customers from the data which they gathered. Now, if a franchisor is going to be liable for every time his franchisee doesn't adequately protect the data of his customers, this is not just going to be a hotel field. I mean, every $5 purchase you make at every fast food operation before long is going to be a mother load of information about that customer, where they shopped the last time, did they or did they not want cheese, what kind of car do they drive, how many people are in the car when they pull up at the drive-in, drive-through, et cetera. So it's going to be every industry. And the notion of franchisors being liable for what steps are taken or not by every one of those franchisees on data protection is just an enormously looming problem, I believe.
Yeah, I would agree if it's headed in that direction. Wasn't there another case involving, or a regulatory action involving, was it Aaron Reynolds?
Yeah,
Something
Aaron Rentals, it's kind of a squalid case, but I mean,
Yeah,
basically,
it was.
their franchisees who do the rent-to-own products had software installed that would tell you far more than anybody should want to know about the people who rented that set, what those people were doing in their bedroom while watching that television set. And Aaron's apparently knew about this and either didn't do anything to stop it or did very little to stop it.
Those are different facts, definitely. I was not aware of the
Well, I'm not
knowledge
sure
part
how
of-
much of that's in there, but anyway. So, I mean, the point is that this whole issue of relationship between these two entities and what are the legal consequences of it are far more expansive than I think most people realize.
So is there a theory of negligent franchising Like negligent hiring, can you be liable if you pick a bad franchisee? Because that seems like that's one way of getting around some of the corporate separate.
You know, there was a crazy case years ago involving BMW, a BMW, and a BMW dealership that took someone's deposit.
But who's going to sue you for picking a bad franchisee?
Yeah.
The person who was hurt by the
Customer.
franchisee, yeah, the person who was injured by the franchisee.
That you should not have allowed him to operate under your name.
Yeah, I mean, that's.
Because you knew that they were dishonest, or
It may-
you knew
I
they
don't
were
remember- I don't
about to go
remember that
bankrupt,
case,
or.
but-
Yeah, I mean, that would be, I'm just trying to think of ways that people might try to argue around the corporate separateness.
Is it almost like bad faith insurance claims that, the irony is that if the insurance company screws up badly enough, you may be able to get coverage for more than your limits because they didn't do their job. And so, in effect, what you're saying is you're kind of shooting the moon that I was so bad, you should have known I was that bad.
Well, no, but again, it would be the consumer saying.
Okay, no, I'm even
This-
getting at the franchisee saying,
Oh,
you
okay.
shouldn't have picked me. I was that bad. I was so much a babe in the woods.
Stop me before I tell
Yeah,
you.
yeah.
Chris, you're saying maybe there's some business models that give you
yeah.
access to people's homes. So you're the TV
Oh, yeah.
repairman
No, I
franchise,
understand that.
and then it
Well,
raises
just
the
using
stakes.
the Renaissance or the rental furniture thing, right? That you as the franchisor basically hired this person, independent contractor relationship, but you were negligent in the arrangement that you made and not screening them out or something.
Yeah.
I don't know.
Well, a couple of things. First of all, it's going to be a tough road to hoe because courts have even much short of that have stopped it in cases which tried to hold franchisors liable beyond what it says in the contract for essentially being a bad franchisor, and have said essentially there is no such thing as a standard of care for franchisors that we're going to uphold beyond what the parties have agreed to unless there's some flat provision of law. So going beyond that and saying there's also a standard of whom they should pick and not pick, I think is even a further reach. There is, in Brazil, there's a provision in the Brazilian disclosure law which requires you to spell out the profile of the ideal franchisee, which essentially requires you to tell a prospective franchisee what they think will make for success or failure. They don't say it that way, but that's what it boils down to. Why do they care what you think is the profile of an ideal franchisee other than that? So essentially, you're laying yourself open to liability, and franchisees will sue. I'm saying, well, you let me be a franchisee even though I came nowhere near your profile. So, I mean, I think there is some thought about that, but it's pretty limited at this stage.
Mm-hmm. Yeah, I think that Chris' idea is interesting. You can also think of looking at the period of training that the franchisee got. If the period of training was shorter than the period of training that normally is given in the industry, this may also be an indication for the negligence of the franchisor. If the franchisee got training of 2 weeks, and in the industry, fast food franchisees get training of 4 weeks, so this may be an indication for negligence by the franchisor, and consumers may try to have a claim.
Well, you know, the traditional approach in this country has been laissez-faire. Traditional approach has been disclosure. If you tell a franchisee how much training he's going to get or not get, and as long as you do whatever that says there is no liability. But you can see it taken, I mean, I could see it taken further step. I could see it saying, and you must further disclose, how does this differ from what the standard is in your industry? If this is half of what most other people do in your field, I think there'd be tremendous argument against it. You can find that out yourself. It's no business of the government to make people tell. But that's the sort of thing you're talking about.
But I'm talking
for the
about the
third
claim by
party,
the
it would
consumer.
make
Going back to vicarious liability.
The consumer doesn't read the disclosure document. The consumer suffered, and he didn't read the disclosure document. He doesn't know.
I saw your trademark. I thought they would be competent. That
Yeah.
sort of, yeah.
Yeah,
I thought
I'm
they
talking
cooked the
from the
hamburgers long
consumer
enough that I
perspective.
don't get sick from it or something.
It's like a service mark kind of situation.
I mean, lawyers do it all the time, right? I mean, lawyers have been trying to expand the realm of liability to get deep pockets for as long as there has been tort law, I guess. So, It's not surprising that
And you have the
franchisees-
legal liability too, the Courtney versus Waring case from way back, where you get the lawyer who
Yeah.
represents franchise parties and really isn't a specialist, and so you get the issue not just of malpractice with respect to his client, but third-party rights maybe of others who relied on that.
But I think, yeah, and he was also an officer of the company, and
Yeah.
it was a negligent failure to disclose or include something in a disclosure document. I remember that case really well, as, being here in
That
California.
lawyer retired the next day, actually.
Yeah. I almost quit a job because of that case once. But I got my way, and what I wanted in the disclosure document ended up in there, but.
For you.
But I still feel like what Phil is talking about, this NLRB and the data privacy issues. I can deal with, the issue of consumers and, their perception of the kind of service I'm going to get and the experience I'm going to have in the restaurant. Those are things that go to the heart of the franchise. But these other issues, the sort of what I call the backroom issues, the how you handle your wage and hour, what your HR policies are, whether you're complying with tax laws. Those are endless.
In this, we've had a cycle in vicarious liability in which courts began to be much more refined in their approach. And they would end up saying not what kind of control you exercise generally, but with respect to the specific instrumentality. So that if somebody gets hurt by a franchisee's use of a particular piece of equipment or machine, whatever it was, the determination of whether the franchisor would have liability would focus upon to what degree did the franchisor exercise control over how this particular instrumentality was used and how that training was used. But now, with the things we're talking about now, it's moving back toward what it was, so that you can end up being liable even if you didn't have anything at all to do with whatever caused the injury. If somewhere else in your operating manual you exercise control over something totally different, that is frightening, because it means that you're going to have to dilute your protection of the brand across the board for fear that some sport somewhere is going to pop up that you're going to be liable for, even if you didn't have any particular control over that activity. I think that is counterproductive, and I hope it gets stopped.
See-
Well, if I could add on to that, I think it gets even scarier, I think, in this day and age, when we've seen such a proliferation of regulations, and regulations for privacy and healthcare, and when you operate in one of those industries, be it healthcare, insurance, securities, and you as a franchisor have primary reporting responsibility to one federal regulator that demands you perform certain oversight functions. Any predictions on, one of these vicarious liability suits cropping up, and you as the franchisor being able to, plaintiff's counsel is going to come in with a laundry list of everything you did? What do you think the chances are that you could redline off the ones that you owed as a responsibility to another regulator?
Well, there is I can't remember whether it's required by law or just we do it. I can't recall practically, but if the franchisee is in a particular industry, which is clearly heavily regulated, then one of the disclosures that you make is you need to know that you're going to be under the environmental regulations dealing with so-and-so, or the hazardous materials dealing with so-and-so. So there's already something like that. The problem is that if you're going to have to say to him, and by the way, there's 717 other regulations that you're going to have to be aware of at the federal level, and now we want to talk about state, county, and local, this room's not big enough to hold the disclosure document. So I just think that at some point, one hopes cooler heads will prevail. But I think it's much too early to predict the direction this is going in, given a hungry bar looking for ways to restore their former position in American society. I suspect there'll be lots more litigation like this before any of that gets resolved.
Well, I guess maybe this is a little hard to prognosticate, but wouldn't a number of plaintiffs' lawyers say, in effect, if you just, in effect, got rid of that whole differentiation and just permitted liability based on the conduct of the franchisee or the franchisor, it doesn't really matter, that the system would adjust, that franchising would continue, it would obviously be dramatically impacted, but there are many other reasons for franchising. Because you will see often this notion that if apparent liability or actual liability were no longer kind of issues, but just, it was resolved in effect all in favor of the plaintiff, that franchising would just disappear.
But it'd be a godsend to the insurance companies who would start writing
Yes.
policies aimed at, we will protect you, the franchisor, against any claim anybody makes against any franchisee, anytime, for anything.
Yeah.
That'd be a
Before-
pretty hefty premium.
The problem probably from the insurance company's perspective, and I should disclose them on the board of a small insurance company, is what's going to happen is before that, so really what's going on here is you've got deals set up and the courts are redoing the deals retroactively. My guess is the same thing's going to happen to the insurance companies before they have a chance to write the type of policy you're talking about, is that their current policies are probably going to be read broadly to cover stuff that they never intended and charge premiums for, to cover the liability that the franchisors never thought they had and never dealt with in their So, and I think you're right, Robert. It's going to work itself out. It's going to have consequences. A lot of it's just, this is really opportunism in the same way we were talking about before, right? This is sort of, you take advantage of the current situation and somebody comes out better, the system adjusts, and longer term, yeah, it's going to work its way out. But in the meantime, there's going to be costs.
Well, I think you're going to find that since these insurance policies are not long-term, you renew. And my guess is you're going to sit, that every one of these, you're going to sit down and they're going to say, we want to make clear that what this language means is X, and if you don't want it that way, we'll not renew you.
Liability's got a long tail, though. If you've done it before you renewed the policy,
I agree.
You're in trouble.
But I do think you're going to see people trying to refine the language and the understood coverage of existing
Oh,
policies.
yeah, no doubt, absolutely.
But Rob, the answer, I think that, sure, it'll work itself out in the long run, but in the long run, we die. I just...
Well, to play the devil's advocate, because I don't know enough about how it would work out, is it's an issue which a lot of it, obviously, if the franchisee had assets or insurance or anything else, it wouldn't be an issue. It's a relatively small percentage of the cases, but it's a significant enough liability that people get very concerned about it. And if you just didn't have that issue, well, it'd be one less thing to squabble over, but it would be one more thing to have to insure, cover, deal with. That would be the...
It's just hard to know in advance, what that exposure is. And I would just see it resulting in higher royalties and, and then that gets
burgers
passed
get more
on to the
expensive.
consumer. Yeah.
As the only franchisor in the room, doesn't this discussion terrify you?
You can't imagine, no, you can't imagine, because as the only franchisor in the room who operates in a highly regulated industry, 99% of what we do in compliance manual, we have compliance manuals that are like this.
Right.
I would hate for plaintiff's counsel to get a hold of that. I feel I can explain it away based on the regulators that I'm ultimately reporting to, federally required, but how many hundreds of thousands of dollars am I going to spend in discovery requests and depositions and everything else to get to that point? It would be nice if there was a clearer line that said, again, those are outside the scope of consideration when we're looking at control.
And you won't be able to keep that manual away from plaintiff's counsel ultimately. I can tell you.
But if you went the other way, then the manual wouldn't matter as much from that point of view. From that point of view, you'd just be liable. You'd just hopefully have insurance, or your franchisee would be insured sufficiently that you wouldn't be fighting over that. It's like the whole thing of, if the laws were uniform, we wouldn't have lawyers fighting over conflicts of laws and all these other things. They'd cut to the chase of was there really liability in the first place? What are the damages? You know, that sort of
But
thing.
you're right, one thing you said is right. One of the things it would immediately do is every franchise agreement would increase the amount of insurance that the franchisee was required to carry. That's the very first thing that would happen. Probably make it a non-viable enterprise for the franchisee because
Well,
the premiums cost him more than anything else.
And the other thing I could see, and because we're seeing this play out with Obamacare or the Affordable Health Care Act, is if it's really complicated, which I imagine this would be, everything bad is going to be blamed somehow on something, whether there's support for it or not. You know,
Yeah.
that franchise went out of business, or we had to redo the model or whatever. But so I was just throwing it out, just as devil's advocate.
As academics, do you think that there is fertile ground for much more of the sort of study that we just scratched the surface of today? And this is the first symposium ever conducted on franchise law, to the credit of the school and of Robert for being a nudge. Is there more opportunity? Should this be done by others and more like this?
Well, since this is an area I do a lot of research in, sure. There ought to be more. There ought to be more funding, more travel opportunities. I think there's plenty of fertile ground. I mean, even with Norm, who is you're not a beanie wearer, but a novice in terms of taking what you do know in corporate governance and applying it into franchising. I think even just in what he heard us talking about in the morning and before he talked, he could see some areas that could also be looked at. There's a lot out there. There seems to be the data too, as Chris was pointing out, that can drive some of the research in a way that's more difficult in some other fields.
I mean, because I think you've got the franchising research like Uri does, but then you can also do covenant not to compete research or arbitration research using franchise contracts. And there's not much of that that's been done, I don't think.
And they're available, which isn't true.
And they're available, which
For
is
the most
the
part,
beauty
the
of it.
contracts, and it's the problem with employment contracts.
Right.
Most of them aren't. Yeah.
I mean, other than CEOs, which I assume is what you've. So no, I think there's. It depends on it depends on sort of. This is kind of mixed, I guess, a mixed panel in the sense that you've got franchise experts and non-franchise experts, and everyone can learn from each other. The question is really sort of, I think in some ways the arbitration people are more interested in the franchise research than the franchise people are in the arbitration research sometimes. But no, I think there's huge opportunities to use publicly available contracts in ways that just haven't been done as much as they could have.
Right. It's a mixed bag, making it accessible to the non-expert because it is a very specialized area of law.
Yeah.
And so you got to run.
Well, that's another thing. It's a very specialized area of law, but the fact is, in some ways, it's the most general area of law there is because most of franchise law consists of what we all learned in first-year law school, but refracted through a prism of something called franchising, even if there wasn't anything called franchising when you went to law school. I mean, in some ways, it touches everything: contracts, agency, torts, across the board. So, I mean, for example, you tell me I should know this, but I don't know. Does the ABA Forum on Franchising have an academics division?
I don't think they.
I don't think they do. They have every other kind of division.
I don't think.
Do you know, Mary Beth?
I don't think they do.
I don't think they do. And I'm not even sure if they have a discount.
Well, in that case, the hell with it.
Yeah. I mean, the origins were obviously antitrust, so it's
Right.
kind of moved from that some, but
They do have a,
That's another illustration, right? That antitrust people can learn from franchising
yeah.
examples. I mean, all the tying stuff is franchising, initially franchising.
And Uri was talking about Rajiv Dant and Phil, is it Phil Kaufman? Patrick Kaufman. And there are people like Francine LaFontaine at University of Michigan, and then one of my colleagues who's emeritus now, Roger Blair at University of Florida, just outstanding economists who, especially I think Roger, really have written in some really good law reviews, years ago because of that focus on antitrust law, and so they come at it.
That was when we had antitrust law.
Yeah.
Well, Michelle, you tell us what you want us to do.
Well, if there are no other questions, I think Robert prepared a short conclusion.
It will be very short.
So we can go ahead and move on to that.
Okay, it's a very short. I guess I'll go back to the podium.
Do you want us out in the audience, or do you want us sitting here?
Oh, I'd love an audience.
Okay.
So that,
Why don't we just turn our,
I'd like to
we'll
at
just
least
turn our chairs around. That's
I'd like some company.
I'd like to at least increase the audience to being more than the number of panelists, which would be impressive. And I don't know if there it is.
Is there another costume change?
No, I think that's.
No, we're going to wear hats.
I think that's it. No PowerPoints, no more costumes. And Bill would point out I'm wearing one of the fanciest ties I ever wear for this conference, the camel tie, which has brought me success in the past, so I had to wear it. Again, I just wanted to thank Min, Michelle, Brian, and others for helping set this up, and I really want to thank all of the speakers for coming. Obviously, Yuri gets the award for coming from the farthest, but all of us came from places not nearby in the sense of coming from places like Michigan and Iowa and in Kansas, and it's the middle part of the country. And so we came from far to be here, but I think it was well worth it, and I do hope this is a spur for, if not Stanford again, certainly other law schools to host seminars like this. We have a rich tradition, I think, in franchise law of having practice-oriented sessions, and internationally there are groups, and there are, as Phil mentioned, and Yuri talked about, there are societies of academics for which lawyers are certainly welcome, but a distinct minority, for which franchise law is an interesting area to examine. But at the law schools, I'm just hoping that there will be a little bit more of an emphasis on trying to incorporate franchise law topics more and more into classes, if not having a whole course devoted to it, at least much more of an emphasis on trying to build it into the curriculum. I think it provides a wonderful opportunity for schools that have, say, a business school to think about having programs which are multidisciplinary, not just in the sense of having one professor or maybe a team-taught class, a business professor and a law professor, but maybe even having a team of students. And I believe at Syracuse is where I think I heard of this, and I'm sure it must be taking place at other schools as well, but I think it was at Syracuse that a colleague of mine who teaches business law was telling us at one of our Academy of Legal Studies and Business conferences, which is business law professors who teach law, who have legal credentials. Most of us practiced law before we went into academia. At that conference, this Syracuse University professor was talking about team teaching, where they do bring in the students from different parts of the university. And this isn't just a conference, it's not just a guest speaker, it's a whole semester of team teaching. It requires a lot more work from the professors, which is probably why it hasn't happened as much in terms of you've really got to know what your colleague is going to be talking about so that you can merge it into what you're doing. But I think franchising would be an excellent place to be advancing that. I know at University of Florida we have a center for entrepreneurship, and we have a center dealing with retailing, And both of them bring in people to talk about franchising, either from the practical level, occasionally academicians and others. But we still haven't gone as far as what I understand that we're doing, not so much in franchising, but more generally in some area. It might have been environmental law, it might be some other area where you bring in the business issues and you also deal with the legal issues. And I think that's what needs to be done at business schools, at law schools, and almost certainly in other grad programs. So hopefully that will take place. I don't know if there were any questions or comments before we close out. Michelle, did you have anything you needed to say?
Thank you all for coming, and thank you to our audience members that hung out for the entire day.
Well, and thank you very much, Michelle, for arranging for the wonderful weather. I commend you for that. And again, thanks to all the people who attended, and especially thanks to the speakers for coming here from far. I look forward to seeing the final result in terms of the papers that are published. Thanks.